I'd almost throw up. I think it's fine to be told what all the stuff is. You have to go through on this, because you know, it could have took me on transport. Fortunately, granted, would be able to help do it at home. At the last choice, it's about going to the dialysis. But that appointment in August, yes, that's probably when they're going to go in, do something. As Rock knows, I told him that whatever time. Anyway, it's everything to the same. He might have a good kidney, but he's gonna have a heart attack sometime. His wife has to do. God forbid, crossed me here last year, and 2 weeks of heart attacks. I'm seeing that for the last one. I mean, it was constant 2 weeks. For one, right? You comes in, it's like, no, I'm familiar with your families. Your family history. It's wordy, it's horrendous. It's a bad, it's horrendous. So they just put on with some time on their video. That's got to be somebody. Oh, you had more hard to actually just have it with everything. Lots, there's lots. Students. Old Springs and Trines. But I didn't say so. No, it's not. Yes, sir. Hey, yeah, well, yeah, you don't do that. I think it's, I think I see it. Yeah. No, I won't. So, I think this real like that. It's a people won't care. That's great assumptions. I'm not afraid of it. That's how they do it. Yes. Good hanging, brother. It is like especially. I'd rather be felt than not. Only coat so. Oh. Yeah. No, I'm not familiar with that treatment. But Alice to have this extremely nice. The only problem is I don't think that ball hurts enough. It don't hurt. It don't hurt. That's 60 even not to be really smack it over the 60. When the death is yes, yeah, that's no. Yeah, he wasn't any good. Anyway.
Did you get my email? We need to talk.
All right, tonight for this court panel session, John Chris Martin.
Good morning, thank you. Please be seated.
All right, good morning, everyone. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When I call your name, please say present or here. Jerry Brown. Kirkland Huggins. Max Juarez. Mr. Juarez was ordered to be in court this morning. Has indicated that he's having some kind of vehicle issues and is on Zoom at this time. We'll talk about that in just a moment. Gary McKeever. Shiloh Scott.
President Council, Your Honor, thanks for waiting for us.
Thank you, Mr. Harrison. Patricia Arvizo. Jonathan Daniel. Daniel Admire. Douglas Bennett. Linda Bennett. Wyatt Berkwin. Wyatt Lane Berkwin. He is in TDC. I don't have that on my docket. We'll recall that case. Trevion Bowie is in TDC. He was transferred to TDC from Smith County. We'll recall that case. Carissa Coleman. Trevor Glover. Isaac Jenkins. Norma Mendez. Tanya Mons. Or Tana Mons.
Your Honor, she's gonna be 30 minutes late.
We know why.
Traffic,
Hang on, one at a time. What?
traffic coming out of Fort Worth.
Same. Reno Moreno. Anthony Murray. Stephen Richardson. Michael Rodenbaugh. Angel Salazar. Angel Salazar. Is Angel Salazar here?
Judge, he should be in custody of Texas.
Yeah, I just didn't know, but somebody was announcing something out there, so I'm trying to figure out what that's all about.
That is Jose.
Okay. Edgar Vasquez. Pascal Waters. Ray Williams. Chrissy Kaiser. Jose Salazar. Jennifer Schaefer. Joshua Brown. Joshua Neal Brown. He's here. Zachary Cooley. Carrie Criswell. Joshua Huffman. Philip Swallows. All right, anyone else in the courtroom, your name's not been called, you expect to be on the docket today? Seeing no one, counsel, we ready?
Judge, we have two. Sorry, go ahead.
James Lanier was picked up in Bill James Texas, BPC, out of Harlan County, so he was on the docket.
Lanier,
That's this afternoon, and no, he's in our jail.
He is here.
Yes, I bet we had him bitch warranted.
Mr. Wells,
Judge, we have two. The first one, Jonathan Daniel.
Mr. Daniel, if you'll come forward, sir. This is cause number CR 25-38, State versus Jonathan Daniel. We're set for pretrial. Some understanding, Mr. Wells, that you're standing in for Mr. Eisenberg.
No, excuse me. That's on Aviso. I'm hired on Mr. Daniel, but I've only been hired for about a week. And so I would like another pretrial on Mr. Daniel.
Say that again. We show that Mr. Eisenberg was retained on Mr.
He still is. There hasn't been a motion to substitute. I've been hired. I may leave him on it with me or not, if that pleases the court. But I would like another pretrial so I can do a little better assessment of it. I've just been on it just over 1 week.
Say,
No objection, Your Honor.
all right, there being no objection, court will reset Mr. Daniel for pretrial. Mr. Wells, I've got August 12th or 14th.
Let me look. August 14th is fine, Judge.
August 14th. All right, Mr. Daniel, you're ordered back for pretrial August 14th at 9 a.m. Once you sign your notice of setting, you're free to go.
You can wait down the hall. And Judge, the second one is Patricia Avizo.
Ms. Arvizo,
And this is the one I'm appearing for, Mr. Eisenberg.
just cut across. There you go. I don't think about it. All right, this is cause number CR 25-91, State versus Patricia Lopez Arvizo, set for pretrial. Okay, Mr. Wells, you said you are standing in for Mr. Eisenberg on this one.
Yes, Judge, and they're working on resolving that. If it's acceptable, you can do a pretrial or you can put it on docket call, either one. He has no motions to file.
Okay, there being no contested pretrial motions on file, court sets this matter for docket called August 12th or 14th, Mr. Wells.
This due the 14th, if that pleases you.
Court sets Ms. Arvizo for docket call August 14th at 9 a.m. Ms. Arvizo, have you signed your conditions of pretrial release yet? Have you met with Mr. West? You have, Mr. West, you met with her? Okay. All right, then, Mr. Wells, once she signs her notice of setting, she's free to go.
Thank you, Judge.
Good morning, Mr. Harrison.
Morning, Judge.
All right, this is cause number CR 24-225, State of Texas versus Shiloh Darnell Scott, and we're set for docket call. Go ahead, Mr. Harrison.
Your Honor, we have a discovery, we have an offer, we just need a trial date.
All right, and can you go ahead and place on the record what the offer is, either state or defense, what the offer is, what's being convicted? And so that I can know that Ms. Scott understands that the court may not allow her to engage in plea negotiations after today.
Judge, my recollection is it was a 10-year TDC offer.
Is that correct, state?
Best I can tell, Your Honor, Ms. Curry has actually been dealing and speaking with Mr. Harrison.
All right, court will set Ms. Scott for jury selection beginning August 4th. Ms. Scott, when you report to the court on August 4th, you will not report to the courtroom. We'll be bringing in a jury that day. Your case will not be set for trial because there's other individuals ahead of you. So you'll report downstairs and my staff will be down there to meet with you along with a pretrial release officer to give you a notice of setting and reset you.
Your Honor, can I have 1 second?
Yes. And you're not required to be here on the 4th, Mr. Harrison. You're not required to be here because she's being placed on the rolling trial docket. And I don't anticipate she's going to go to trial.
I see. So that's not our actual trial date.
That's not your actual trial date. If there's a request for a special setting, we can talk about that. But right now, I would just place her on the rolling trial docket, and she would be on that until her case reaches the top 10, and then which you would be notified that you're potentially going to trial.
Could we approach trial?
Yes. All right, there being a request for a special setting in this matter, the court sets Ms. Scott for trial on March 16th. Mr. Pierce, I do need Ms. Scott though to report monthly. So what I'm going to do is I'm still going to have her come in on August 4th. And she can check in with staff to receive pretrial release services with Mr. West, check in with court staff. And then, but we'll especially set it in March.
Should I put March 16th special setting on our reset notice?
You can. Ms. Scott and Mr. Harrison, I should have a note that she's delinquent $80 on her pretrial release fees. That's something that you're aware of.
No, I thought it was good. I can pay for it after.
All right, what I want you to do is go to the pretrial release office, check with them, and any delinquencies you have, get those paid for. All right, you're free to go.
Thank you, Judge.
Thank you, Mr. Harrison. Mr. Harrison, if you'll wait for just a moment. Mr. Bratton, is it?
Yes, it is, Judge.
All right, Mr. McKeever. This is cause number CR 25-81, State versus Gary Ray Van McKeever, and we're set for pretrial. Go ahead, Mr. Bratton.
Your Honor, we're requesting a reset of the pretrial. I've talked to the prosecutor. There's some discovery needs to be completed on this. This is our first appearance after arraignment.
What's the discovery issues?
Your Honor, my understanding is that he has not had access to the CAC interview, and so he would need to be provided with a link, since that's not something that we could place on the portal. I've already explained that process to Mr. Bratton, and we'll make sure that that gets done.
All right, and Mr. Bratton, if I reset you for August 12th or 14th.
14th, if we could,
14th?
Judge. Yes, sir.
All right, and you'll should be able to review the CAC video before then. Court sets Mr. McKeever then for pretrial August 14th at 9 a.m. And once Mr. McKeever signs his notice of setting, he's free to go.
I've got that prepared.
Thanks, sir. Yes, sir. Thank you. Mr. White, are you ready?
Yes, I can.
Who'd Doug call first?
Jose Salazar.
Jose Salazar. Cause number CR 25-84. Mr. Salazar is set for a pretrial today. Go ahead, Mr. White.
Your Honor, we had this pretrial set because we needed some information from the DA's office in regard to a prior conviction out of Dallas County on family violence. And my understanding with talking with the state is Dallas County is not being very cooperative as far as sending anything up here for us.
Your Honor, we've requested the certified copies. We just haven't received them yet. I haven't seen any response from Dallas County to see whether they are just slow in processing it or what exactly the process is, but they have been requested. We just don't have them yet.
And Your Honor, that was one of the things that I was going to be looking at as far as doing a pretrial is possibility of attacking the prior to turn this into a misdemeanor.
All right, court will reset Mr. Salazar for an additional pretrial. You want August 12th or August 14th, Mr. White?
August. I've already got some things on August 14th, so I believe that probably be best.
All right, court sets Mr. Salazar for pretrial August 14th. 9 a.m.
Sorry, was that the 14th or the 12th, Your Honor? 14th. Thank you very much.
14th. Like next,
Whoever you come up on.
Chrissy Kaser, CR 25-47. All right, Ms. Kaser is set for docket call today. Go ahead, Mr. White.
Your Honor, I have been able to speak with the state and they have made us an original offer. And we haven't really had very much time to consider anything on that.
You asking for more time to consider? the offer?
If we could, Your Honor.
Dave?
No objection, Your Honor.
All right, there being no objection, court sets Ms. Kaser then for docket call. You want the 14th,
I believe that probably.
August 14th at 9 a.m. Jennifer Schaefer. This is cause number CR 25-24, State versus Jennifer Diane Schaefer. We're set for pretrial.
Your Honor, I filed the normal pretrial motions that I do, and I don't believe the state has any opposition to any of those. I would bring to the court's attention that we've had some problems trying to find time for her to come in, and this is the first time I've ever seen her. So if we could have maybe one more pretrial to give me some time to interview her.
State.
No objection to an additional pretrial, Your Honor.
All right, court recess Ms. Schaefer for pretrial August 14th at 9 a.m.
Don't run off.
And Mr. White, you're court appointed on this case, correct?
That is correct.
And Ms. Schaefer, you understand that because you're on indictment for a felony case, also because you've received a court-appointed attorney responsible for payment of supervision fees and also its fees.
Yes, sir.
And I understand here that you are delinquent on your payments to pretrial release.
I just made payments this morning,
How much did you pay?
130.
130? Okay, thank you.
That's a good move. And Your Honor, I believe that is all I have in front of you unless you got a surprise for me.
Looks like I do not.
All right.
Have a good day, sir. Morning, Mr. Schmidt.
Morning.
Who would you like first, sir?
Daniel Admire.
Mr. Admire, sir, if you'll come forward. This is cause numbers CR 24-250 and 251, State versus Daniel Jack Admire for docket call, final docket call. Go ahead. Mr.
That's correct, Judge. We're announcing ready for trial this time.
All right, and can we place on the record what offer, if any, was made to Mr. Admire so that the trial can know that?
Your Honor, I can look it up in just a moment here.
While Mr. Hartwell's doing that.
And Judge, I'm gonna ask for a special setting on Mr. Admire's cases. If it's possible.
You'd be looking at April of next year.
Understand. And Judge, my recollection of the state's office 14 years.
And Your Honor, I believe it was to go forward on the sexual assault of a child for 14 years TDCJ.
All right, thank you. And Mr. Hartwell, is any objection to the request for a special setting in this matter?
No objection, Your Honor. State would join in that request.
All right, court sets Mr. Admire for trial before the court on April 6th, 2026. Court is also going to set Mr. Admire to appear on the jury selection docket so he can check in with pretrial release and court staff beginning August 4th. So Mr. Admire, you'll check in on August 4th. You'll see the staff. They'll give you a notice of reset. You'll check in with pretrial release services, then you'll go. Okay. And you'll do that every month until we reach your case for trial on April 6th. I'm sorry, yeah, April 6th.
Just so you know what I wrote on. be here to sign a reset on August 4th. But our
Court is
special
setting
separate.
that, both cases.
Our special setting is April 2026. That's what the court's docket. Okay. Between now and then, once we do it, some of these settings, when we get closer to April 6th, probably I would say February. All right.
Ms. Bennett, if you'll come forward. This is cause number CR 25-4, State versus Linda Diane Bennett for docket call. Go ahead, Mr. Sherman.
Judge, we did, separate plea.
Right, you want, that August 12th date?
Sure.
All right, will that be a morning or afternoon plea?
Morning, plea.
All right, court sets Ms. Bennett for plea before the court, August 12th at 9 a.m.
Douglas Bennett.
Mr. Bennett. This is cause number CR 25-3, State versus Douglas Wayne Bennett for pretrial.
And Judge, I show on your docket, it shows Nolan White. I think that was an error.
It shows what?
Nolan White, I was retained by Mr. Bennett.
Yeah,
My docket says no.
my docket says that you're retained.
Good, okay, we're clear. I just want to make sure that paperwork was in order. Mr. Bennett, we're here for pretrial. We don't have any contested. We'd ask for that, August 12th date.
All right, there being no contested pretrial motions, court sets Mr. Bennett before the court, August 12th for docket call. Mr. Coleman,
Yeah, no doubt.
Ms. Coleman?
Yes.
I'm sorry, I think so, Mr. All right, this is cause number CR 25-35, State versus Carissa Bernice Coleman for docket call. Go ahead.
Judge, we're gonna ask for an additional docket call setting.
Any objections from the state?
No objection, Your Honor.
Court sets Ms. Coleman for docket call August 12th at 9 a.m. She gets her notice, she's free to go.
And Judge, Ms. Coleman anticipates having, inpatient surgery, I believe on the 7th, correct, of this month. I just wanted to make the court aware of that fact, and it may not be possible for her to travel. She's coming from Detroit. Post-surgery, if the court wants to keep that setting, that's fine. We can just provide the court with medical documentation. After the fact, it's up to you.
You want to move it further from
I
August?
think
12th?
so, Judge.
State,
State wouldn't have an objection to that, Your Honor.
what about September 16th?
Yeah, we'll give that a shot.
All right, court sets Ms. Coleman for docket call September 16th at 9 a.m.
Wilma Mendez.
Ms. Mendez? This is cause number CR 25-52, State versus Norma Linda Mendez for docket call.
Yours are folks, I couldn't hear you.
Okay. Judge, I think we're pretty close on Ms. Mendez. I'd ask for a final docket call setting on her.
No objection, Your Honor.
All right, court sets Ms. Mendez for final docket call August 12th. Nani.
Yes, I can, sorry. Thank you.
Marino.
Mr. Moreno? This is cause number CR 24-242, State versus Reno Santana Moreno for docket call. Go ahead.
Yes, sir. Judge, I'm in receipt of some additional digital evidence that's been provided to me that I need to review. I'd ask for an additional docket call setting.
No objection, Your Honor.
All right, there being no objection, court recess Mr. Moreno for additional docket call August 12th. I showed that Mr. Moreno delinquent on his pretrial release fees, $40. Is that something you pay today, Mr. Moreno?
Not today, probably be like Wednesday,
Wednesday, next week?
no,
This week? Tomorrow?
tomorrow.
Tomorrow? Okay. All right, then make sure you get that paid this week.
Yes, sir.
Anthony Murray.
Anthony Murray? Cause number CR 22-336, State versus Anthony Wayne Murray. I believe we're here on a status today. Go ahead.
We're here on a status, Judge. Obviously, we need to get Mr. Murray off the status setting. We've got him available again. It's been quite some time since I've had access to his person. I'd ask for the court to allow me to have a pretrial setting so we can get it back on track.
All right, court will grant that. Mr. Schmidt, is August too early or do you need more time?
A little more if that's okay.
And is Mr. Murray going to be traveling from out of state or is he?
He's coming from Shreveport, Louisiana. Yes, sir.
Okay. Any objections from state court setting this in September?
No objection, Your Honor. Thank you.
All right, court sets Mr. Murray September 16th. 9 a.m. And that'll be for pretrial.
Stephen Richardson.
Mr. Richardson? This is cause numbers CR 25-12 and 2024-219.
May we approach real quick?
Yes,
Judge?
please.
Thank you.
All right, I believe we were set for a plea today. What's the announcement today, Mr. Schmidt?
Judge, at this point, we're going to announce ready for trial on Mr. Richardson and ask to put him on the jury selection document.
All right, court sets Mr. Richardson for the jury selection docket beginning August 4th. At 9 a.m. So Mr. Richardson, you'll report back on August 4th.
Michael Rodenbaugh.
Mr. Rodenbaugh. This is cause number CR 25-55 State versus Michael Lance Rodenbaugh for docket call. Go ahead, Mr. Schmidt.
Judge, I'd ask for a final docket call setting on Mr. Rodenbaugh.
No objection, Your Honor. Thank you.
There being no objections, court sets Mr. Rodenbaugh for final docket call, August 12th, 9 a.m.
Edgar Vasquez.
Mr. Vasquez. This is cause numbers CR 24-292, CR 24-293. I believe that we're set for docket call for Mr. Vasquez.
That's correct, Judge. I've received medical records on Mr. Vasquez. I have them in my office. I haven't had an opportunity to view them. I think they're material to the case. I'd ask for another docket call.
No objection, Your Honor.
All right, there being no objection, the court will reset docket call August 12th, 9 a.m. Mr. Vasquez, I show that you are a tad bit delinquent on your pretrial fees of $70. Can you pay that today?
Yes, sir.
You can pay $70 today. So when you leave court, I want you to go over to the pretrial release office,
Yes, sir.
pay the $70, okay?
Yes, sir.
I'll talk to you.
Okay. Thank you.
Pascal Waters.
Mr. Waters? It's cause number CR 25-20 State versus Pascal Todd Waters, and we're set for docket call.
Judge, we ask Mr. Waters for a plea on the August 12th date.
Morning or afternoon?
In the morning, sir.
All right, court sets Mr. Waters then for plea before the court August 12th at 9 a.m. Once he gets his notice, he's free to go.
Ray Williams.
Mr. Williams? This is cause number CR 24-226 State versus Ray Anthony Williams. I believe that we're set for docket.
That's correct, Judge. We're announcing ready for trial, Mr. Williams' case today.
Can we note for the record what the offer was, if any, that was extended and rejected?
Yes, Your Honor.
Violation was 15 years TDC.
That's correct, Your Honor.
All right, court sets Mr. Williams for jury selection August 4th at 8:30. Mr. Williams, you'll need to report on that date, and if your case is not reached for trial, I'm not sure how many cases do we have going trial out there. So with Mr. Schmidt, we don't even have a top 10. We probably have a top 5. We only have about 4 or 5 cases on the rolling trial docket, so he could be liable for trial on the 4th. So.
Sir.
So be here on August 4th at 8:30. I do show Mr. Williams is delinquent on a bond supervision $80 and attorney fees $400.
Yes, sir. I've been for past about 3 months. Well, I've been going through my newborn. We've been in and out the hospital. I lost my job. As soon as I got my job, I lost it, but I have a little bit. It ain't that much, but something to go put on it today. And that's it. But just give me time. I'm trying to put something together, and take care of my business.
I understand. I'll give you time.
Yes, sir.
All right.
See you.
What's your? Did you have Isaac Jenkins here?
Yes, Mr. Jenkins. File number CR 25-126, A versus Isaac Anthony Jenkins for arraignment. Go ahead, Mr. Schmidt.
Judge, Mr. Jenkins' name is spelled correctly on the indictment. He understands the charge. We'll waive formal reading, enter plea not guilty.
All right, the court finds that Mr. Jenkins, having waived the formal requirements of arraignment, enters his plea of not guilty into the record, and the court sets this matter for pretrial hearing. Is August 12th too soon, Mr. Schmidt?
Yes, sir.
The objection from the state, well, actually, how about, let's see, August 26th?
Yes, sir. That's good.
All right, court sets Mr. Jenkins for pretrial August 26th. Ms. Mons? And ma'am, is your name Tanya or Tana?
It's Tana, but I go by Tanya.
It's Tina.
It's Tana.
Just want to make sure I didn't have a typo. All right, this is cause numbers CR 25-99, 2025-62, 2025-20. And I believe that we are set for arraignment, pretrial, and docket call. Let's start with the arraignment in CR 25-99.
And Judge, in that case, Ms. Mons understands the nature of the charges. Her name is spelled correctly. We waive reading, enter plea of not guilty. Asked to carry that to a pretrial.
All right, court sets Ms. Mons for pretrial hearing and cause numbers CR 25-99 will carry pretrial in 2025-209 and docket call in 2025-62. Court will enter her plea of not guilty into the record, finds that she's waived the formal requirements of arraignment. We will set that to August 26th in all cases.
You're good.
Mr. Schmidt, Ms. Mons is delinquent $70 on pretrial release fees. Can you pay that $70 today?
I can pay some, but I have a child with cancer, so I don't work and I only get paid once a month.
How much can you pay today?
50?
50? Okay. Then go and pay that before you leave town. You can leave court now. You can go over there and pay, and then you're free to go.
Yes, sir.
All right.
Probation department, it's right across the street. Yeah, same.
Thank you.
Go.
We call Angel Salazar.
All right, this is Angel Salazar, CR 25-6162 and CR 25-89. Go ahead.
And Judge, based on my communications with Ms. Curry, Mr. Salazar, I believe early June was going to take a resolution in his juvenile cases, which sent him off to Texas Youth Prison. And as a part of that deal, the state had agreed to dismiss these cases. I'm not sure what the status of that is, but he should be in custody through juvenile. I anticipated dismissal on all three.
Your Honor, I believe he is in custody on juvenile. As for the specifics of the agreement, I'm not familiar with them, but what Mr. Smith's saying does sound familiar.
Can you contact Ms. Curry and find out? Or?
Your Honor, I believe she's in Rains County under a special prosecution today. But otherwise, I we'd be able to get in touch with her.
We'll reset Mr. Salazar then for status on August 12th.
And Your Honor, if there is in fact, a dismissal that just wasn't filed, we'll get that filed prior to.
Thanks, sir.
And Judge on Wyatt Berkman, CR 24128. I said TDC when you were calling the roll, but I suspect he's in a half.
All right, this is cause number CR 24-128, State versus Wyatt Lane Berkwin. We're set on status. Court will reset Mr. Berkwin for another status to determine if what we believe is true, that he is currently in the custody of a halfway house being released from safety. So we'll reset that to August 26th. Mr. Schmidt, let's go ahead and call CR 24198, State versus Trevion Lakeith Bowie. Show that Mr. Bowie was in custody in Smith County, wherein he was transferred to TDC, the Cofield unit. So if we want a bench warrant, the state want a bench warrant.
Yes, sir.
All right, so we'll reset Mr. Bowie then for arraignment August 26th, and we'll issue a bench warrant to TDC.
Judge, I think I have Mr. Glover. We're gonna do paperwork and we'll be ready.
Okay. Morning, Mr. White.
Good morning, Your Honor. How are you?
I'm doing fine. Thank you for asking. How are you? Who would you like to call first?
Can we call Mr. Cooley?
Mr. Cooley? This is cause number CR 25-72, State versus Zachary Blue Cooley. Mr. Cooley is set for docket call today.
That's correct, Your Honor. Spoke with the state on this matter. We're still working on it. I think the state's gonna talk to the alleged victim. If we could have a reset, I think next time we'll either plea it or we'll set it on the trial docket.
The objection from state.
No objection, Your Honor. Thank you.
All right, Mr. White, would you like August 12th or 14th?
August 14th would be good.
14th. All right, court sets Mr. Cooley then for docket call August 14th. 9 8.
Mr. Swallows.
Philip Wayne Swallows. It's cause number CR 25-16. Mr. Swallows set for docket call today.
Your Honor, we're still trying to come to a conclusion on this. We could have that 14th date. I feel like hopefully we'll have something, tell the court on that. If not, we'll put it on the docket, trial docket as well.
State.
No objection, Your Honor. Thank you.
All right, there being no objection, court sets Mr. Swallows for final docket call August 14th at 9 8. Next, Mr. White.
Mr. Huffman.
Joshua Stephen Huffman. Cause number CR 24-165. Separate docket call.
Your Honor, we're gonna ask that this move be placed on the jury selection docket.
All right, what is the offer that was extended, if any?
Your Honor, it was deferred on a misdemeanor.
Deferred on a misdemeanor?
Yes.
And Mr. Wyatt, have you explained to your client the court's policy of not allowing plea negotiations after docket call?
I have, Your Honor.
And so he understands that he's indicted with a third-degree felony offense, potential range of punishment not less than 2 years up to 10 years in prison, should he be convicted and sentenced.
Correct, Your Honor.
All right, so Mr. Huffman, you understand that if we get ready to try this case and you walk into the courtroom and decide you would rather have that deferred misdemeanor, the court's going to reject that and tell you we're going to go to trial. You
Yes, sir.
understand? All right. Court sets Mr. Huffman then for jury selection beginning August 4th. Mr. White, I believe he's going to be in the top 10. So just make plans for being here on the 4th, and he is liable for trial on that day. Here you go.
And I believe I got a couple of pleas, Your Honor.
Okay.
Mr. Criswell.
Mr. Criswell, CR 24-301. Oh, I'm sorry about that, Mr. White. Technology is a little slower today. Maybe I'm a little slower. It's one of the two. All right, this is cause number CR 24-301, State versus Carrie Lynn Criswell. Mr. Criswell, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. So, Mr. White, it appears that the plea is for a different cause number, correct?
That is correct, Your Honor.
CR 25-152.
Yes, sir. We refiled it as a misdemeanor. And on the record, I'll say that we waive any 10-day preparation on that. It's all under the same facts.
Okay. All right, Mr. Criswell, your name is Carrie Lynn Criswell, is that correct?
Yes, sir.
And Mr. Criswell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work that he's done for you as your attorney?
Yes, sir.
You understand everything that you have read and signed today?
Yes.
Do you have any questions about the paperwork or anything else before we proceed?
The only question I have is the fine, do I pay it upstairs in the district court or downstairs in the county clerk?
It was filed in the district clerk, so you'll pay it here. Any other questions?
No, sir.
Mr. White, do you believe Mr. Criswell to be competent today? And if so, have you explained to him his rights regarding the case?
Your Honor, I believe Mr. Criswell is competent. He understands the proceedings that are pending against him. Went over his rights. He's waived those rights knowingly, totally, voluntarily.
All right, and so was it information filed? I don't see it in the. Sure, I don't see it in the plea pack. Was it information filed?
It was, Your Honor. It was turned in yesterday and file stamped by the clerk and given the new cause number CR 25-152.
Sorry, Mr. White, I'm gonna need just a moment to log into the system. I need to review that information.
Absolutely.
All right, Mr. Criswell, so you are charged by information with a Class A misdemeanor offense of a criminal trespass of a habitation that does carry a range of punishment of up to a maximum 365 days confinement in the county jail and a possible fine not to exceed $4,000. I see that there is a plea agreement in your case wherein upon you pleading guilty to that charge, the state is recommending that you be convicted of the offense, that your punishment be assessed at 2 days confinement in the county jail, for which you would receive time credit served for 2 days, a $1,000 fine, court cost of $270. Mr. Criswell, is that your understanding of the plea? And in addition to that, the state has filed a motion to dismiss upon the plea being accepted in cause number CR 24301, the indicted assault of a family or household. Is that your understanding of the plea?
Correct, Your Honor.
That's what you're asking the court to approve?
Yes, sir.
All right, understanding the range of punishment, understanding the plea agreement, Mr. Criswell, how do you plead to Class A misdemeanor criminal trespass of a habitation?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No objection.
All right, the stipulation of evidence is admitted. Court does take judicial notice of the defendant's judicial confession. Anything further from the state?
The state is in compliance, Your Honor.
All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant of the offense. Court will follow the plea agreement. Court hereby convicts the defendant, Carrie Lynn Criswell, of criminal trespass of habitation, a Class A misdemeanor. Court assesses punishment pursuant to the plea agreement at 2 days confinement in the Van Zandt County Jail. Issues credit in the amount of 2 days for time served. Orders the defendant to pay a $1,000 fine, $270 in court costs. And Mr. Criswell, you said you're going to pay your fine today.
I'm not gonna pay all of it. I can set up a payment plan.
How much are you paying today?
I can pay $100. I'll have to go to my truck to get it. I didn't bring anything in with me.
For having sentenced the defendant, Mr. Criswell, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Sergeant Martinez. After that, then step across the hall to the district clerk's office, make your payment, and they'll set you up on a payment plan, but you gotta tell them you need a payment plan. Yes. For the record, discretion, the court is granting the state's motion to dismiss in cause number CR 24301. Mr. White, who's next?
Mr. Brown.
All right, this is cause number CR 24-255, State of Texas versus Joshua Neal Brown. Mr. Brown, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You lower your. All All right, Mr. Brown, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work that he's done for you?
Yes, sir.
Do you have any questions about your paperwork, the case, or anything else?
No, sir.
All right, Mr. White, do you believe Mr. Brown to be competent? And if so, have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea?
Your Honor, I believe that Mr. Brown is competent, he understands the proceedings, opinion against him. He's waiving his rights knowingly, intelligently, voluntarily, and I've also explained the advantages and disadvantages of a deferred adjudication, and I'm satisfied that he understands the agreement that he's entering into.
Thank you, Mr. White. All right, Mr. Brown, you have been charged by indictment in count 1 of a third-degree felony offense, assault of a family or household member by impeding breath or circulation. A third-degree felony does carry a range of punishment of not less than 2 years in prison, up to a maximum 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty to that crime, the state's recommending to the court that the court consider the evidence, defer a finding of guilt, meaning not convict you today, rather placing you on community supervision for a period of 6 years, along with a fine in the amount of $2,500. In addition, as a condition of your community supervision, you'll be required to participate in complete anger management through the Van Zandt County Probation Department. And I believe a part of the agreement is also that count 2 of the indictment will be dismissed. In addition, you'll have court costs of $290 and reimbursement fees of $35. Mr. Brown, is this the plea agreement you made with the state?
Yes, sir.
All right, understanding the range of punishment, understanding the plea agreement, how do you plead at this time to assault of a family or household member by impeding breath or circulation?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Brown, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just to acknowledge the state is in compliance, I believe you should have received the victim impact statement.
I accept this. Anything further from the defense, Mr. White?
No.
Mr. Hernandez, in the victim impact statement that you've provided, there's a reference to restitution of the amount of $6,408.74. That doesn't appear to be addressed by the plea agreement. Is that something the state has a comment on?
Your Honor, we never received any additional information or justification for that amount. That's the only place that we've seen it. So I have nothing further to add.
And I would note, Your Honor, most of that, Mr. Brown and now his ex-wife, that their divorce is obviously completed. And all of that was taken care of. Divorce is my understanding. They divided the property. They also had businesses that divided up.
All right, court's going to consider the evidence, and the court, for the record, has reviewed the victim impact statement. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant. Court will follow the plea agreement and a recommendation from the DA's office. Court hereby defers a finding of guilt on the third-degree felony offense of assault of a family or household member by impeding breath or circulation. Court places Mr. Brown on 6 years community supervision, orders him to pay a $2,500 fine to complete anger management through the Van County Probation Department as a condition of probation. Court finds that the state has agreed to dismiss count 2 of the indictment. Court assesses a fine of, court cost of $290 and reimbursement fees of $35. Mr. Brown, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. And have you come over here to be fingerprinted, and then you'll meet with the probation department to get more information.
All right, that's all I have this morning. Excuse.
Yes, sir. Thank you, Mr. White. Pardon?
Gary Don Brown, Your Honor.
Come on, Mr. Brown. All right, this is cause number CR 25-31, State versus Jerry Don Brown. We're set for arraignment. Go ahead, Mr. Harden.
Your Honor, we received a copy of the indictment this morning. I explained it to the defendant. He knows he's charged with second-degree felony aggravated assault with a deadly weapon. His name is spelled correctly. He understands the nature of the charge, understands its penalty range of 2 to 20 in PDC and an optional $10,000 fine. We'll waive the reading of the indictment and enter a plea of not guilty.
All right, court finding that Mr. Brown, having waived the formal requirements of arraignment, enters this plea of not guilty into the record. We will set this matter for pretrial. Do you have your calendar with you, Mr. Harden? Looking at either August 12th or August 14th.
12th of August, Your Honor.
August 12th. All right, court sets Mr. Brown then for pretrial August 12th at 9 a.m. Mr. Brown, I show you're somewhat delinquent on your pretrial release fees. It says $50. You paid that today? Yes. Okay. So once you sign your notice, then go, you know where the pretrial release department is, the probation department? You know where that is? Come over here and meet with these officers and they'll tell you how to get there. Okay. And then just go over there, you'll go into the business office, pay, they'll give you a receipt, you'll be good to go. All right. Anything further, Mr. Harden?
Nothing further, Your Honor.
All right.
I received the plea papers on Mr. Lanier and the one that's on the 130 docket, so I will be ready for it.
All right, very well. And make sure he gets his notice of setting.
Okay. He has signed them.
Okay. All right, this is a sanctions court hearing, cause number CR 20-125. Kirkland, Wade, Huggins. All right, Mr. Huggins, let's see. Last time we were in sanctions court, I ordered you to pay $65 to probation. You did that. I ordered you to pay $40 to court collections. You did that. Also ordered you to do 10 hours community service. It says that you did that. Where did you work your hours?
The Freedom Boom event, in Van, I have a copy of the email to me.
No, you're good. I appreciate you bringing that. It's always good to bring your proof, but I show that you did that. I was just interested to see where you did it.
Yes,
And also ordered you to attend counseling, and it says that you complied with that. So you're in compliance with everything. That's very good. All right, so what I'm gonna do is I'm gonna order you back for another sanctions court. So what we're gonna do, Mr. Huggins, is we're gonna continue down this path until I can see that there's a substantial period of compliance.
Yes, sir.
Once I see that you're gonna comply with everything, then I will give you an opportunity to go back on probation regularly without having to come to sanctions court and show me that you're doing everything. Does that
Yes,
make
sir.
sense? All right, so the more often that you're in compliance and the more times that we can do that in a row, then I'll get to a point where I'll trust that you can go back on probation without me having to intercede.
Yes, sir.
Okay, so I'm gonna have you come back on. Let's come back on August 12th. And the week before August 12th, I want you to have paid $65 to probation, $40 to court collections, just like last time, 10 hours community service, and bi-monthly counseling.
Yes, sir.
Okay, same things. All right.
Yes, sir.
So we're gonna give you a notice of setting. And then try to get all that done before the week before court. That way they have time to compile the reports and get them to me.
Yes, sir.
Okay.
The only reason with the Freedom Boom, it was the last weekend of the month because it was right at 4th of July. And that was the only reason that it had to wait till right at the end.
Yeah, I understand.
Yes. What else? Yes, ma'am. Yes, ma'am. Thank y'all for your time.
Thank you, Judge.
You're welcome, sir. It's fine. I was just making sure that I looked down. I couldn't remember if we had pled this guy. So he's good. He's no rush. We got plenty of time. This is cause number CR 25-0008, State of Texas versus Trevor Cole Glover. We're entering a plea today, I believe. Is that correct, Mr. Schmidt?
That's correct.
Mr. Glover, if you'll raise your right hand, sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Swear.
All right, you can lower your hand. Your name is Trevor Cole Glover.
Yes, sir.
And Mr. Glover, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work that he's done?
Yes, sir.
Do you have any questions about the paperwork that you've read and signed about the case or anything else before we proceed?
No, sir.
In this case, you are indicted with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than 1 gram, less than 4 gram, and that does carry a range of punishment of not less than 2 years up to a maximum 10 years in prison should you be convicted and sentenced. And I see that there is a plea agreement in this case, and upon your plea of guilty, the state is recommending that the court defer a finding of guilt, not convict you, but rather to place you on 5 years of community supervision, ordering you to pay a $1,500 fine, $180 restitution, and for you to have a substance abuse evaluation as a part of your community supervision or your probation. In addition, Mr. Glover, you would have court costs of $290, reimbursement fees of $535, and restitution of $180. Do you understand the range of punishment and the plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Mr. Glover to be competent today? And if so, do you believe that he's entering into this agreement intentionally, knowingly, involuntarily, and that you've also explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Glover, at this time, I would ask you, how do you plead to possession of a controlled substance in penalty group 1 greater than 1 grams, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Glover, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
Court will review the evidence at this time. Right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby defers a finding of guilt, places Mr. Glover on 5 years community supervision, orders him to pay a $1,500 fine, $180 restitution, orders him to take a substance abuse evaluation as a condition of community supervision. Court orders him to pay court costs of $290 and reimbursement fees of $535. Mr. Glover, how old are you?
25.
25?
Yes, sir.
Have you ever been on felony probation before?
No, sir.
So you're a very young man to be on felony probation, wouldn't you agree?
Yes, sir.
You understand that through the work of your attorney and through the offer of the state's prosecutors here, you're being given an opportunity to have this felony accusation set aside if you complete all of the conditions of your probation. You understand that?
Yes, sir.
You understand that if you do not do what you're supposed to do and you end up becoming the subject of a motion to adjudicate or a motion to revoke, and God forbid you receive a felony conviction for what you've already said you're guilty for, do you understand what kind of adverse effects that could have on you for the rest of your life?
Yes, sir.
You understand how serious it is that not only would you be looking at a potential prison sentence from that 2 years to a maximum 10 years and a fine up to $10,000, but a felony conviction stays with you on your record for the rest of your life. There's no getting it expunged, non-disclosed, short of clemency from the Texas governor. That would follow you for the rest of your life. That would follow you every time you apply for a job, you apply for credit, anytime you get stopped or have interactions with law enforcement, that's going to pop up. You understand that?
Yes, sir.
Now, felony convictions would make your life increasingly much more difficult. You understand that?
Yes, sir.
So you have an opportunity here. If you have a drug problem, you need to get help with it now through probation, through the resources to you. I see here that you had fentanyl. You took fentanyl. Is that correct?
Yes, sir.
And is that what caused you to overdose?
Yes, sir.
Do you want to die?
No,
So why would you risk your life taking something like that?
I had a problem. I'm trying to fix it now, taking care of it.
What was your problem? Drug problem?
Yes, sir.
And can I ask, Mr. Glover, what led you down this road to begin with?
I'm not really sure yet.
Do you have a horrible life?
No.
Do you have people that love you?
Yeah.
Do you have people that help take care of you?
Yes, sir.
Are you an able-bodied individual? I mean, you can get up, you can walk, you can talk, you can think for yourself. You
Yes,
can
sir.
feed yourself. You understand there's a lot of people in this world that can't do that. A lot of people in the world that look at you and say, man, he sure is lucky. And yet here you are in this position. You understand that?
Yes, sir.
I'm giving you the lecture, Mr. Glover, because I hope that I don't see you again. I want to give you the lecture now because I hope that I never see you again. Does that make sense?
Yeah, for sure.
All right. Who's with you today?
My grandfather.
So he took time out of his life to be here to support you. Is that right?
Yes, sir.
Why do you think he's here?
Because he loves me.
Yeah. Do you think he wants to be standing over your casket at your funeral when you die from fentanyl?
No, sir.
He doesn't. How sad would it be for him to have to get up and give a eulogy or something at your funeral
It'd
and
be
say
sad.
this young man with a lot of promise and potential gave his life away to fentanyl? All right, you have an opportunity here, and it's not going to be an easy one. Probation is not easy. A lot of people think probation is just a slap on the wrist and off you go. In fact, it's the opposite of that. Probation is for people that have the ability to, or at least the potential to take care of themselves, be accountable, get a job, support themselves, meet deadlines, do your classes, pay your fines, pay your fees, do your probation, do your community supervision. It's not easy. And it has to be priority one in your life, because if it's not, then you're going to be back in the score facing potential prison.
Yes, sir.
And that would be a tragedy. Really would. Okay. All right, Mr. Glover, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come up here with Sergeant Martinez. He's gonna take your fingerprint. After that, you're gonna meet with the probation department. So, thank you. You're welcome. I believe that concludes our criminal docket for the morning. The court's going to stand in recess until 1:30. Take up the afternoon pleas from the jail on Zoom. Court's in recess.